Recognize the chair of the full committee, the gentlelady from Washington, for 5 minutes for questions.
Dr. Franks, earlier this year, a U.S. appeals court heard a case on whether TikTok could be sued for causing a 10-year-old girl's death by promoting a deadly blackout challenge that encouraged her to choke herself. TikTok pushed this dangerous content to this child's For You page. Do you think this type of personalized amplification or promotion should receive Section 230 protections? And how can Congress reform Section 230 to protect children from this deadly content?
Thank you. So I think that Section 230's benefit of immunity should apply very narrowly for two kinds of situations. One is when the platform is taking active steps to mitigate against harm. So the facts that you are describing clearly do not fit this. This is promotion of harm, or this is indifference to harm rather than active intervention. The other narrow view is in C1 is the question of whether or not someone is being treated as though they are the speaker for someone else's speech. And so in this case, I don't think that this applies either. So I don't think that the facts as you've described them would be something that you should get immunity for. The problem has been that the interpretation, broadly speaking, has been that, in fact, in situations like this, when a company can say, this wasn't our direct issue, we didn't directly do this, that too often has been enough to get that case dismissed. And so I think that is what needs to be clarified at this point. Even though the text of Section 230 itself does not demand that result, there has been so much case law at this point that seems to point in that direction that C1 really does need to be clarified to include limitations that say you cannot use that kind of argument, you cannot get this kind of immunity from civil liability anytime you want. There has to be certain limitations, and those limitations, in my view, should be including things like you can't solicit it, you can't encourage it, you can't profit from it, and you cannot be deliberately indifferent to it.
Thank you. Professor Leary, I mentioned in my opening statement that as a mom, I'm very concerned about big tech and its impact on our children. I want to thank you for your work in drawing attention to the exploitation of women and children online. How has activity such as online sex trafficking, exploitation, and pornography been allowed to exist and grow due to Section 230 protections?
Thank you, Congresswoman. Well, I think we've heard the answer again and again today, haven't we? And that is courts taking what is a fairly clear text and turning it on its head, and they're being led to that point by litigants who are arguing for this massively broad immunity. So what we've seen is courts in the First Circuit very famously a few years ago acknowledging that even if we accept the plaintiffs in that case, 3 girls who were trafficked on Backpage, even if we accept that as true, that is not what Section 230 was designed, that is what Section 230 was designed to protect. Courts have allowed for direct actions, partnering with illegal entities or profiting from them to exploit children in a number of ways, and they have simply regarded those somehow as a publishing action, which it is absolutely not. So that's how Section 230 has been abused in that way, and denying people the opportunity to get into that information where we can show how these companies are in fact engaged in that activity.
Thank you. Dr. Stanger, how might reforms to Section 230 impact smaller tech companies and startups compared to larger, more established platforms who have benefited from liability protections?
That's a great question. There is some concern, sometimes expressed from small businesses, that they are going to be the subject of frivolous lawsuits, defamation lawsuits, and they can be sued out of business even though they've defamed no one. I'm less concerned about that because if we were to repeal Section C1 of Section 230, those 26 words, I think the First Amendment would govern, and we would develop the jurisprudence to deal with small business in a more refined way. I think if anything, small businesses are in a better position to control and oversee what's on their platforms than these monolithic large companies we have today. So with a bit of caution, I think that could be addressed.
Okay, in my time remaining, Dr. Franks, I wanted to go back to this question of Section 230 applying to generative AI technology such as ChatGPT, and if there's anything you want to add to the impacts there that you see.
I'd say two things about this. One, in terms of the harms that we're seeing, especially for sexual exploitation. This is one of the most serious, clearly an urgent situation already in terms of the damage that it is doing to women and girls in particular. And we're seeing that this is a problem not just of the apps and the services themselves, but also of the distribution platforms like X or Facebook or wherever that material happens to end up, which highlights the fact that we need to be thinking about both of those angles of the problem. And to make clear that that should be the case, that textually speaking, that sort of product, generative AI, giving that sort of product in response to inputs should not be the kind of thing, according to even the current text of Section 230, should not receive immunity because they are acting as their own information content providers.
Right, okay. Thank you, everyone. Appreciate your insights on this very important topic. I yield back.
Thank you.